right direction.
After 51 years of it, hey, I understand.
Okay, you are ready now.
All right. At this time then, we will call to order the Code Enforcement Board. This is a special call meeting, and we'll have the roll call first, please.
Ron Birkins, Matt Calvert,
Here.
Lisa Onan,
Here.
Tim Skinner, Alan Taylor.
Here. I'm assuming that the board members that are present have received the email with the minutes from our November 16th call meeting. I would entertain a motion to approve those minutes as submitted, please.
I'll make a motion to approve the November minutes.
I will second.
We have a motion and a second. Any discussion? In favor of that motion, aye.
Aye.
And the motion is carried. Minutes have been approved. The next item is a contested citation based on the citation issued for 239 First Street against or owned by Audubon Loans One LLC. Ray, would you?
Chairman Taylor, may I interrupt?
Absolutely.
Could we have IT resend Mr. Shields his invitation? He's been trying to log on and he has been unsuccessful.
I think we probably ought to postpone or just take a little.
Well, let's take a break and I'll see if we can get it there.
Okay. We'll pause this meeting until they can join us, since that's the next item, obviously, on the agenda.
Okay. Yeah. Okay. Thank you. Teresa, we're texting Corey. Corey's at home today. I wonder if you sent him your.
No,
No, it won't work. Okay. All
he
right.
can do the calling.
Well, we'll see what.
If he says he can.
Okay. Teresa, Corey's sending it to him right now.
I thought it was one universal, but each panelist gets their own link.
He sent it.
Okay. He said he sent it, Teresa.
Otherwise, you know how it shows your name? It'll show whoever's name that link was from.
Ray, I've got a question. Would it be appropriate for you to restate or read portions of that citation?
I would say. That's up to Chris.
I will once the meeting's started officially, I think.
Okay.
I think it would be appropriate for the other party to be in attendance.
Dawn, is your mask a one-day mask?
I wear it one day, but it's a disposable mask.
That would be very hot down there.
They get hot.
The N95s are really hot.
Yeah, I think I got
This
some
is a
plain.
K-95.
Still, those
Yeah.
are,
Well, I guess I'm just used to it.
my daughter and I typically wear the cloth masks, but my son-in-law and my husband wore the surgical masks and preferred them. Be sure you take an extra one every day.
Oh, yeah, with you, into the car. That's a good, yeah, or you'll be buying them there.
You might very well. They've gone up.
Dawn,
Yes.
he has not received the new invitation.
See if you can send him yours and see if he can log on as you. It'll say he's Teresa Ritchie, but we'll all go, he's not.
I think he said either I might be able to rename him or he might be able to rename himself.
Okay, are you still there?
Yes.
In the minutes, we've got our meeting ID and passcode, so I texted that to Dane too.
Okay.
Now, I was gonna say the hyperlink on the email, I just hit that and boom, I'm there.
We're there, under you, Teresa.
Okay.
Okay.
It-
There they are.
All right, good morning.
Good morning.
Okay, Ray, would you proceed with the citation that we're dealing with, please?
Yes, this is a contested citation number 2020-00000906, dated November 23rd, 2020, for the property located at 239 First Street. The property is owned by Audubon Loans One LLC. This citation is first offense for violation of the International Property Maintenance Code 108.1.1, unsafe structures. This was the building that collapsed on the night of August 21st. A notice of violation for condemnation was issued on August 22nd, along with a demolition agreement and statement of liability, giving the property owners 30 days to complete demolition and debris removal. On August 22nd, due to public safety concerns, the building was demolished with all debris left on the lot. That included the adjoining lots building, which was severely damaged beyond repair due to the collapse of the 239 First Street building falling on top of it. We gave them 30 days. On September 11th, we had a meeting with the property owners, and as a result of that meeting, an extension was granted to November 3rd. November 3rd came and went, and I sent a letter on November 13th that stating that no additional extensions of time would be granted. Not hearing much of anything in response to a schedule of removal. A citation for condemnation was written on November 23rd. Regarding the citation itself, facts constituting the offense: the building is on the ground in large pile of debris, creating an unsafe situation. Demolition agreement dated August 22nd, 2020, and signed by the property owner, states that all demolition debris would be removed from the property within 30 days. Although an extension was granted, continued communication with property owner has not resulted in a definitive plan for demolition debris removal. And the corrective action is to remove and properly dispose of all demolition debris from the property. Construction fencing must be maintained around the perimeter until the removal is complete. The other comment that I'd like to make is not only have we not received a definitive plan of action to date, we have had, as you can imagine, public expressions of concern have been mounting for some time on this property with this corner downtown lot. The city requires that this eyesore and safety hazard be removed as soon as possible and requests from the board a final order that specifies a schedule and definitive dates for work to begin and to end. Linda and Terry Dukes, the property owners, through their attorney, Dane Shields, have contested the citation and are in attendance. That's my report to the board.
Thank you, Ray. Dane, would you respond, please?
Yes, I will, Mr. Chairman. I became involved in this matter on December the 4th. We responded to the condemnation citation and filed a contest and requested a hearing. We agree that the cleanup and removal of the debris is of utmost importance. Commenting on the citation itself, though, we believe two things. One, that due to following the directives of code enforcement the day after or the day of the collapse, that the structure was collapsed by executing a contract with Hazex. The building is on the ground now, and we do not believe there is any active risk to the public, as the minimum safeguards to protect the public were taken at that time. And we don't believe that the property is now subject to any more collapse because it's on the ground. So we're back to the job of cleanup and taking the debris off of the premises. And I'd like to discuss with the board for just a moment. We've run into some complexity in this matter, and I'd like to detail that. The adjoining building to the building owned by the Dukes also collapsed. That building is owned by Phelps Lambert. That property owner, through their insurer, gave us notice of a potential subrogation damage claim to their building based upon our building collapsing, which may also involve a cleanup and removal cost for the adjoining building. Now, as it turns out, both insurance companies for the adjoining building and the building owned by the Dukes at 239 First Street, the property in question, is the same insurer. It is Cincinnati Insurance. And we have been speaking with Cincinnati Insurance about coverage to provide for the property next door. Now, the policy on the subject property owned by the Dukes is a liability only policy. So the Dukes insurance policy will provide liability coverage, but it has no coverage for cleanup and removal of the Dukes building, only potentially the property owner. We believe the property owner has full coverage, and the agent for Cincinnati Insurance will not move on providing instructions as to liability coverage because they say their investigation is still underway. Now, that directly impacts how and to what extent Mr. and Mrs. Dukes can proceed in the cleanup and the removal. Now, in the meantime, since the collapse, we have run into somewhat of a quandary with the air quality control through the Commonwealth of Kentucky. Since we knocked down the walls immediately upon the initial roof collapse, they are saying at this point that all the debris, whether it be steel beams or brick or timbers, that everything on the site is hazardous waste, and therefore everything must be packaged in plastic and hauled to a hazardous waste landfill in Davis County, Kentucky. Now, what that triggers is a tripling to quadrupling of the normal removal cost of debris. And since we have an uninsured piece of property here, the property owners are in a real quandary grappling with that six-figure expense. And in the meantime, we are trying to interface with air quality control regarding any flexibility that they may have in their initial directive. Now, I know that the city of Henderson, through Ray Nix, has been kind enough to check with air quality control also on the project. And to date, we've gotten no flexibility. Now, in addressing that, since I've become involved, we have hired interstate environmentalist specialist who on August 21 appeared on premises and took samples to be analyzed so that the firm could then approach the air quality control regarding flexibility of removing parts of the debris that are undisputably not adversely affected by potential asbestos that may have been in the roof. We are not aware of air quality control taking any steps to come inspect the site. Mr. Dukes has also gotten 4 appraisals of companies that can come in and that specialize in cleanup and disposal of hazardous waste, attempting to get an estimate that he can handle out of pocket, which is what we're talking about. What we're asking the board, we agree here that this is a mess. We agree that it is unsightly. We agree that it needs removal. But in response to the protest, we do believe we have satisfied the minimum safeguards to protect the public as dictated by code enforcement, and that the public is not at an active risk as we sit here today, and that there's no additional collapse. So what we are asking this board is forbearance and to allow us to discuss a definitive date where we can submit a good faith time frame on getting this project cleaned up and the removal to an appropriate facility consistent with the directives of the Codes Department and the Commonwealth of Kentucky, which has intervened in this case. So that's what we are requesting at this point, is to discuss a schedule that would be appropriate in your eyes to get something definitive going in this case.
I have a question.
Yes,
What,
sir.
what would be your estimation of an appropriate amount of time if we, the board, decide to back up or extend this deadline? What would be an appropriate time frame in your opinion?
Alan, we believe that we can come back to this board and present a definitive plan and time frame within 45 days. Now, I was going to say 30 days, but we've got holidays right in the middle coming up through Christmas and New Year's, where government officials are going to be not in the office. So if y'all would allow us 45 days, then we would appreciate that to present a definite plan.
Chairman Taylor,
Yes.
city manager would like to address the board at this point, if you'll allow him.
Certainly.
Thank you for allowing me to speak. I think there's been a lot of information shared today from both sides, but from the city's perspective, this has now gone on for at least 4 months. And we understand that the Division of Air has been involved since early on due to questions regarding environmental hazards involved with the debris pile. However, the city receives calls weekly about the unsightliness, the safety hazards, as well as the economic impact that it has on adjoining businesses. And it is very difficult for the city to sit and not be able to give a affirmative answer to when this is going to be remediated. Thus, I know Mr. Shields has asked for 45 days. It's going to turn around from 45 days. Then how long is it going to take to clean it up? It could be next summer before this is cleaned up. I also want to indicate that the site is not secure. The public can get in, and that's of a concern as well. So that's the position of the city at this point in time, and we ask that the board try to ask the owner and their attorney to expedite this as soon as possible. We have been more than lenient through this, and it's time to get it resolved. Thank you.
Thank you, Buzz.
I think what Buzzy's concern is, if we come back in 45 days to then set the plan, that just sets the plan out longer. And I think that the city would be willing to, the city understands that things have, that they've got to appeal to the air quality control. And this has been going on for a long time, and it took them a long time to hire Dane, and we're very happy that they hired Dane. But that we would like a not 45 days to set the plan, but a period of time, a date definite to get it cleaned up at least, or a shorter time for the plan to be submitted.
Comments from the board?
I think I agree. It's still a hazard to the public, whether it's, the public being able to access the site or asbestos and lead paint leaving the site due to wind and rain. So, I think I would be in favor of having a plan presented by our next meeting, but I don't think I would be in favor of extending it.
My concern is that, if they don't get the results that they need to be able to financially do this, what do we do then?
If I could respond to that, Lisa, that's a good observation. My clients are committed and have the resources to remove and dispose of the debris under any scenario. However, that being said, as business people and members, good members of the business community of Henderson County for many years. These are the owners of Audubon Loans on the Cloverleaf, a nice looking building. They've been a good corporate citizen of this county and has complied with all of its rules, its ordinances. This is a major hit due to the classification that the entire site is a hazardous waste. Now, we don't think that's accurate, but if that ends up being the case, once we have an opportunity to interface with government, with not just going there and saying, hey, would you give us a break, but going into air quality control with definitive results from an expert saying we can separate the good from the bad. We can dispose the bad, if you will allow us to dispose the good under normal procedures. So, and again, we're running into the holidays here. When we try to make commitments to the government and to boards such as yourself, I like to make commitments that in good faith we can meet and we can accomplish. So the 45 days was what I suggested at the request of the chairman. I understand and agree with what Buzzy has said, and I understand and agree with what the city attorney has said. And I think we're all on the same page. It does my client no good to have debris and mess sitting in the middle of the city of Henderson under the watchful eye and competent eye of Ray Nix. I mean, this is just a problem that if we don't clean it up, it's going to go from bad to worse, and we are aware of that. Lisa, we will clean it up regardless. It's just the difference between 30,000 and 3 times 30,000, or maybe 4 times 30,000, because all of the estimates that we've gotten have been right at 100,000 or above, with open-ended expenses that could increase. And that is, it's not devastating, but it's substantial. And plus, the insurance won't give us anything definitive. So if y'all want us, what I would ask is that we come back in whatever amount of time that this board feels appropriate, taking into account the holidays, for a definitive plan. And then once we have a definitive plan, we can execute it. How long will it take to execute a plan? I would say not more than 60 days. But y'all have the ultimate control of that, and we will respect your decision.
Don, I have a
Mr.
question.
Chair. Go ahead, Alan.
The fees for this citation, I think a contested citation, the fee is $200. Can that be multiplied on like a schedule of every 30 days? There's another $200. until, where I'm going with this is, can we structure a financial incentive for the owners to get it going, get us a response with a plan, or therefore they are subject to additional fines and fees?
Alan, what would happen is Ray would have to give multiple citations. So what we have this from time to time, and what it is you do a multiple citation. So if you look at your board pack or your board notebook, it gives you first citation, second citation, third citation cost. And I apologize, I don't have mine in front of me. But what would happen is every 30 days, Ray would issue a new citation.
Well,
And you could do it that way.
what I
But
would,
you all don't have the authority to go outside of the ordinance. The ordinance sets that up. So but what Ray can do is continue to cite them. Am I making sense on that? And really, this is a Chris question. Chris, I kind of intervened for you.
No, but you answered it well. Yeah, if we start getting a series of daily violations and they're going to add up, then you're going to have an aggregate of several $1,000s. If it's $200 a day, my math tells me that's $6,000 a month, and you can abate that, and you can essentially probate that, but you can abate it upon remedying the situation. So the ordinance says that you all can assess the fine, or you can give a time to remedy the situation, or both. So within that, I think, you'll have to have Ray come back, because I think we just have the one here, and that's only $200. But you can come back, and if Ray's cited them daily, you can say, well, we'll abate that as long as you comply with your plan, because that gives the incentive that you want.
My suggestion is that I feel like that they are working on a solution. And like I said, they have Dane helping them. My suggestion is that their date starts on the 28th, and they have 30 days from that day.
The 28th of December?
Yes. So
Or
we get through Christmas, not much is going to happen next week. So Monday, the 28th starts, and they have 30 days from there. Is my suggestion. From that day to come up with a answer.
Dane, the reason that I feel like the fine is justified is because of the lack of any response from the November notice that your clients received. Basically, no communication. You were in violation. You were notified. There was no response. I understand the extenuating circumstances as far as dealing with the air quality people and the debris removal complications, the insurance. I've got all that. But to have no response, zero, to a citation, to me deserves some slight penalty. And I don't disagree with Lisa's suggestion that they would give you another 30 days to come back to this board with what we've requested. That's where I'm leaning.
And
I've
Mr.
got a
Chairman, and Lisa, we would be, I think that is a reasonable response from this board, and we do appreciate your consideration, and we would be agreeable to that.
Comments?
Yeah, this is Ray. I'd just like to make a statement that pretty much since the beginning, Kentucky Air Quality has been notified and knows the situation. They have jurisdiction over this project as far as the specificities of removal. There has not been a whole lot of contact, I don't believe, between the property owners and air quality. I think there was initial one. I don't know how many times they have communicated, but I do not know if they've set up a time to actually meet with them regarding their latest site inspection by the interstate, and whether that has been communicated and they've sat down to hash out any final meeting and determination on what and how this is to be removed. I think that is the stumbling block, and the sooner that gets done, the quicker this project will get going.
How does the board feel about a continued citation process to kind of motivate the owners financially to move as fast as they possibly can?
I didn't think we had the authority to do that.
What,
Yeah, Ray
Lisa,
will have to start the process.
I'll let Chris answer that.
Ray will have to start that process. I think what you got before you is a contested fine amount of $200, and you can then assess that and direct that the respondent come back in 30 days with a plan. In the meantime, Ray can do whatever he needs to do to cite it daily. And when you come back, then you'll have daily aggregate amounts that'll have a lot more at stake.
And one other thing, on the 30 days, I think that we've got some issue that people are getting behind the fence and taking bricks and taking things, and yeah. And so if we could get requests that the Dukes have that fence more secure, because there are some openings in the fence, and we understand there are people who are getting in there. In fact, one of the people brought a brick that their mother had painted for them from behind there. So we know that there are people who are going back there. So if we could, as part of the 30 days, have them just get that fence more secure than it currently is, that would be great. Because the last thing we want for the Dukes is someone to get hurt back there.
Did you understand?
I tell you that the adjoining property owner, the Lamberts, they've actually placed money in an escrow account that we can that can be accessed to clean up their portion of the property, and that's why we have excited them, because they're ready when they get everything resolved. The money's there for their portion.
Jane, would you respond to the request for additional fencing security on the site?
I think my client would be willing to make sure that site, that the fencing is secure, and will post it with no trespassing. I guess anybody, if they wanted to, can cut through a fence or climb over a fence if they're going to trespass, but we will post it and make sure the fence is more secure, so that any law-abiding citizen would know that they are not to be within the interior of that fence. So we will do that.
Well, I've noticed myself that literally you can walk right around the barrier that exists now. I mean, there's really open access to the property, even with the fencing that's there. So I myself feel like what's there is very inadequate as far as preventing trespassing or entry from someone else.
Yes, sir. So we will take steps to address that very legitimate concern.
Buzzy, you need to make a comment?
Thank you.
Mr. Chairman, I got another question or two just to follow up on. A week ago Friday, I believe, was when the Dukes had the Interstate Company in taking samples on the site. And did you all have any results back on those tests at this particular time? And I did get word from Kentucky Air Quality that they were also on site taking their own samples.
Oh,
Just checking to see if they had any results back yet.
we do not have any results from air quality control. Now, we do have, I was just handed a document from our Interstate Environmental Services that has 4 samples at 4 sites. And Ray, I can share this with you. I'm not sure really how to interpret these. Would the board just, I am happy to share this with the codes department.
Okay.
Is that sufficient? Because I'm not really qualified to interpret these and try to explain them. There's pictures where the samples were taken, and they were taken from the front of the debris, the front right corner of the debris, the right side front debris, the right side center of the debris, with 2 of the places where roofing was present. And there's markers on site showing where they were taken.
Well, I would like to recommend to the board a motion that the citation be issued for the $200 fine, that multiple citations will be forthcoming in the next 30 days from Mr. Nix, and that we will convene 30 days from the 28th to hear from the property owners and their attorney.
A second, or are you making the motion?
No, I'm suggesting that that motion be made.
Okay, I will make that motion.
I'll second.
And is there any discussion or further discussion or question about that motion? All in favor, aye?
Aye.
And that motion is passed. Ray, do you have any comment relating to that instruction?
No, I'm clear. Thank you.
Okay. Well, I think our business has been concluded then at this point. And Dwayne, I'm assuming then you're going to post haste get the information to Ray on the assessment?
Yes, sir. We will do that today.
Okay. Anyone else have a comment? All right. Then that item has been voted on and the motion's been passed. Ray, we have a report from you on uncontested citations. Is that correct?
Yes, we have one other item of business here.
Mr. Chairman, may we be excused?
Yes, you may.
Thank you.
The uncontested citation is citation number 2020 -0000731 dated August 21st, 2020 for the property located at 1132 Powell Street. The property is owned by William A. Skinner. This citation is first offense for violation of the International Property Maintenance Code 108.1.1 unsafe structures. This has been on our list for condemnation for 2 or 3 years. There was an event back in 2016 where first responders were called to a toxic situation inside the house. Upon our arrival, not only was the interior toxic, but the exterior conditions of the residence was also toxic. Our general comments on our inspection checklist was that it was unsafe for habitation. The utilities have been shut off for 3 years now. It's really an imminent danger to anyone entering due to the porch and partial roof collapse. This is our final stage to move this to our demolition listing for getting quotes and getting the house torn down. So this is the condemnation citation for that.
Okay. Well, there is no other business on the agenda to transpire. This was a special call meeting. So, Teresa, a question for you. Do I need to come by the office and sign the motion and the minutes for this meeting?
Yes, I will be sending Mr. Hopgood the template that we've used in the past for him to finalize what the findings of fact were from today's meeting. Once I have that, I'll give you a call and we can meet for you to sign it.
Very good. Well, I call this meeting adjourned then. Thank you all.
Merry Christmas!
Merry Christmas.
Merry Christmas to everyone. Thank you.
Christmas.